Yes, recording has started. So please don't turn on your camera, maintain your privacy, don't unmute at any time. We don't want to impede in any way or to interfere with your privacy. I know it is very, very important. Nevertheless, our recording has started. So guys, I am going to beg the 29 of you to participate as much as possible in our today's session, because some of the questions that I will ask will be clear cut. I will try to move through the course outline as much as I can, noting that some areas maybe I will not touch much. Um, and first, I don't know if you have your books near you, because there are a few things I would like to highlight before I proceed to our course outline. That is on the areas that might be tested that much on the aspect of drafting. Okay. The number one will be the judicial review application. I understand there's a confusion recently by the Honorable Justice, Justice, is it Chigiti SC, or it is, I don't think it is Muita, the one in charge of judicial review. Uh, I don't know how we move away from what the Supreme Court has said in those two authorities. I believe you are aware of them, of the Supreme Court. I don't know if he's still looking back pre-2010, but most tested in criminal litigation will be judicial review applications. Also noting that we are in the constitutional era, because everything now it is petition, left, right, and center. You might also be required to draft a constitutional petition. If you may have had sight of maybe your project work, I'm not saying that is what is required. Sometimes there are different ways of making these applications for judicial review. Others go by way of constitutional petition. Specifically, if you look at Article 23 of the Constitution of Kenya, I don't know if it is F, I don't have my constitution, you realize that judicial review remedies are some of the orders that you can seek by way of constitutional petition. So whereas we can use the judicial review way, whereby you will be required to file, you will be required to rely under the Law Reform Act, that is Section 8 and 9. You can also be required to rely under Order 53 of the Civil Procedure Rules. Okay. There is also the Fair Administrative Actions Act that was enacted pursuant to Article 47 of the Constitution of Kenya. You have a leeway of also seeking the judicial review remedies through that law, whereby you can file a normal JR application, or you can decide to go by way of constitutional petition. So you have seen petition, be it in the Finance Act, be it in now we have another good one. I don't know if you have heard sight of it, the housing, the housing, Affordable Housing Act has been challenged in court. Okay, please, that one of the housing, it is a well drafted petition, so you also need to look at it. You will also be required as number 3. I don't know if you are noting down a petition of appeal. Can someone among us maybe tell us what is a petition of appeal? Anyone? You can raise your hand up. Anyone, please? Petition of appeal. I'm waiting. This is the only way that I can know that I'm not talking to myself, guys. A petition of appeal. Any answer is correct, no wrong answer. We are here to make mistakes and maybe correct them all together. Anyone? Petition of appeal. Yes. Nyakio, take it away. Thank you.
A petition of appeal, in my opinion, is one that outlines the reasons why an appellate court should review a verdict.
Thank you. Is it, when do you appeal from what court to what court? You know, there is petition of appeal, there is a memorandum of appeal. So when do we do that? From what court? Thank you. Your answer is correct. But you will
Is it from the High Court?
To where?
The Court of Appeal.
Yes, I can differ a little.
Okay.
Yes, but thank you for trying. I know when I'm going to say it, then you will never forget again. So you will realize in criminal litigation, yes, Lisa, thank you. Take it away.
Let me try. From the magistrate court to the High Court.
Thank you. From the magistrate court to the High Court, petition of appeal. Okay? Therein, it is just normal the way that a memorandum of appeal is drafted is the same way a petition of appeal is drafted. It outlines the grounds of appeal. Okay? In the year 2022, that question was number 2A. Was number 2A. That is the examination of March examinations 2023. Petition of appeal. So if someone would have drafted a memorandum of appeal, then that person would have lost some marks there. So it is a document that is drafted when you are appealing decisions of the magistrate court to the High Court. Okay, petition of appeal. Such that when you are appealing the decisions of the High Court to the Court of Appeal, you use a memorandum of appeal. Okay, the same applies. Okay, then you will now be required to draft the next document, would be a memorandum of appeal. You can as well be required to draw a notice of appeal. Okay. Then now, if I can ask my good friend, you are not my friend yet, but that is fine. Lisa Kimathi, please go to the last topic. Last topic of our course outline.
Excuse me.
Yes.
Just a clarification. You said the petition of appeal is from magistrate to High Court, and the memorandum of appeal is from
High Court to Court of Appeal.
All right, thank you.
Yes, thank you. Please scroll juu kidogo hapo sawa. Okay. The reason I'm jumping to let's say start with number 15. Number 15. Thank you. The reason I'm jumping or skipping to after number 14. Let me see. Number 13 is what? Number 13. Lisa, number 13. Okay. Yes. Specialized prosecution or specialized prosecutors. We put them together with private prosecution. This area of law, you will realize that maybe you will not be taught much because it will be mostly in that term. So there is this book called, is it Judiciary Bench Book? Bench Book, it was drafted in 2018. Please look for that book. Bench Book, it was done in, it is also available online, but you can get a copy at KSL from that guy who print things. Yes. So you realize that another thing, you will draft habeas corpus application. Someone has disappeared, you look for that person. Okay. Very, very important. Another one is extradition application. Most of the time, because extradition is complicated, maybe you'll be asked to a question theoretically and then follow the relevant procedure on extradition. Nonetheless, you might be required to draft one. Very, very important. Another one, private prosecution. And these are simple applications that you will be invited to draft. Another one, bail and bond applications. Okay, you realize when we'll go back up there later, we will talk about bail and bond. There is an application that is made there. Something happened to Matiang'i. A very important application was drafted. The High Court of Kenya had the exclusive jurisdiction to hear that particular application. It cannot be filed at as any magistrate court unless now you realize, if you will examine the questions thereafter, you will see what happened if the magistrate court is 200 kilometers away from a high court station. What do you there? What do you do there? You realize things like that. More importantly, you will be required to draft a judgment. You will also be required to draft a ruling. You will be required to draft counts and charges. You will be required to draft maybe a revision application, very, very important. It came in 2012, if I'm not wrong, 2022, okay? And maybe some procedure of inquest or something like that, or procedure of transfer of cases. Having said that, I just wanted to give you an outline of the foregoing, such that you can have at least maybe know what will be expected of you in terms of drafting in criminal litigation. So now, Lisa, maybe you can take us to the first one, back to number one in our course outline. Yes. So now, unit one is introduction. You have already done it. So you have already been told the substantive aspect of law in your undergraduate program. You have as well been, the principles of criminal law. So nothing much that we'll talk about in that topic one, but remember, principles of criminal law, you might be examined upon them when you are required to at the CLE. More importantly, let us talk about jurisdiction and structure of the courts. This is like something that is straightforward, okay? Maybe someone can give us that structure. I know it is on the screen. For example, can someone tell us what is the jurisdiction of the magistrate court? What are some of the matters that we hear at the magistrate court? Anyone? Anyone, please? Yes, Lisa?
I think for criminal jurisdiction of magistrate court, we can say that it can entertain all cases, but we leave out those ones that are entertained in high court, murder and treason.
Murder and treason? Yes. Any other? I think they should be 4. Someone to put the next 2? She had said that at the magistrate court, they can hear all matters of criminal nature, except maybe those that are reserved for the High Court. Which one are these? Yes, Lisa?
the international criminal law crimes like genocide and then admiralty.
Okay, very good. Very good. Can I have someone else? Can I have someone else? Yes. Kebongo Kadza.
The magistrates court cannot listen to matters regarding presidential election cases.
Yes, they cannot. But let's say now in terms of maybe criminal law or criminal litigation. Kebongo?
Murder, they can listen to murder cases.
Thank you. Yes, Ngoge?
I would also like to add that the magistrate courts have jurisdiction on civil matters. However, they have a pecuniary cap of some sort, whereby I think it's the chief magistrate cannot listen to matters whereby they have to award, is it 20 million? Beyond 20 million, then it goes down for the, I think it's the senior resident magistrate, 15 million. The resident magistrate for senior principal, I think it's 7 million. Then for the principal magistrate, I cannot remember the rest. But there is that cap. Yeah.
Okay, thank you, Ngugi. However, you will need to go to your section 7 of the Magistrate Court Act for you to know the hierarchy of the magistrate courts, because I have seen that you have said senior resident magistrate. That cannot be above a senior principal magistrate. Okay, please just Google your look at your Magistrate Court Act, then you will see the structure or hierarchy of the magistrate courts in Kenya. And correct, they don't listen to matters above 20 million, that is in civil nature. I however want to ask, maybe I want also to learn, do magistrate court listen to robbery with violence cases as well as attempted robbery with violence? Can a magistrate give a death sentence? Maybe someone to guide me on that aspect, or to guide all of us. Anyone? These are things that you know, guys. Yes, Gitonga Martin.
Yes, so
yes.
Yeah, so the magistrate can listen to matters of involving robbery with violence and also even up to attempted murder. Yeah. Yes.
Okay, thank you. Gitonga, have you spoken before I call Kebongo? Gitonga? You can unmute.
I've spoken.
Oh, okay. Yes, Kebongo.
He has already said my point. They can listen, because death, because they can give sentences of death. So they can listen to murder matters.
All right, maybe Laura has another opinion. Omurunga.
So I don't think they can listen to such matters, including murder, treason, robbery with violence, and attempted robbery with violence. They are preserved for the High Court.
Thank you for that contribution. Maybe Munyo Melody, maybe you can tell us something. Yes.
Okay, personally, I'm of the opinion that they can listen to cases involving robbery with violence, because if you look at the resident magistrate, he can issue up to 7 years. the resident magistrate who is at the lowest rank, the magistrate hierarchy under Section 7, but the senior resident magistrate, as well as the principal, senior principal, and the chief magistrate, they have the power to issue death penalty. So they can actually listen to matters involving robbery with violence. Yes.
Okay, that is very interesting, and your argument is in line with some decision. I don't know which code is it, Kakamega, but from one of the western counties, it has never been cited or supported anywhere in Kenya that a magistrate they have jurisdiction to hear murder cases, since they give death penalties in other matters. So could I be in order if I can give you all that assignment? And maybe if we are going to have any other opportunity to discuss about this, because this is practically an oral examination question. Okay?
Yes.
It is an oral exam question. Yes, Melody.
I can refer you to Nyaoke versus Ministry of Interior case. I think that's the case you're talking about, where the court said that, well, historically, magistrate courts have not been hearing murder cases. Murder cases can only be heard in the High Court, but this is just an historical injustice to put it as that. It can sound like a historical injustice in such that it limits the grounds for appeal of the accused person. So ideally, magistrate courts, if you look at the Nyaoke versus Ministry of Interior, ideally the magistrate courts can actually listen to murder cases. But in practice, murder cases are heard at the High Court. So the judge in the Nyaoke versus Ministry of Interior was for the idea that actually murder cases can start at the magistrate courts. This will now offer the accused person quite a number of will offer the accused person quite a number of appeal, like places to appeal, that if the murder case starts at the magistrate court and he's not satisfied with the decision, he can appeal to the High Court, appeal to the Court of Appeal, and even appeal to the Supreme Court.
Okay, thank you. Thank you for that contribution. I will come back to you shortly. Kevin Mudini, my lord.
Yes, good evening.
Yes, proceed. Unmute. I can see your hand is up.
Can you hear me?
Yes, I can hear you.
Great. I'd refer to the Civil Procedure Code. This is chapter 13, whereby it says for the case of murder, it shall be resolved in a subordinate court or the first class, presided over by a chief magistrate. So I guess technically the magistrate court has jurisdiction, but to be specific, the chief magistrate. Yeah.
That is
really,
interesting. Did you say civil procedure or you say criminal procedure?
Oh, criminal.
Criminal procedure.
Yes, that is actually it's chief magistrate, senior principal magistrate, a principal magistrate, or a senior resident magistrate.
That is on murder.
Yes, that is on murder. Yes.
That is interesting. I don't have my criminal procedure. I don't have my criminal procedure. Murder is a capital offense, and the practice has been said by Melody. It has been a reserve of the High Court of Kenya. I know of a decision by J.B. Odunga, Justice Lesit, and another judge sitting at the Court of Appeal in Mombasa, whereby they refuse certification on the grounds that the Melody presented, that on the aspect of appeal, that the avenues of appeal are limited. So let me leave this to you as your assignment, so that you can figure it out. And it is good when you are making argument for or against, you have an authority to back. For example, let's say in the case of Melody, maybe some panelists would have been really happy for her. But since let us close that, do your research and see what is the correct position in as far as capital offenses are concerned. Okay? Can a magistrate also have jurisdiction over matters relating to treason? Okay? The jurisdiction of the High Court is also anchored in the Constitution. Maybe someone can tell us something very quickly in 1 minute on the aspect of jurisdiction of the High Court. Anyone? Please, time is not on our side. Yes, Osodo, William.
Okay, the High Court is established under Article 165 of the Constitution, and it has unlimited jurisdiction and inherent powers in its trial capacity. So it has supervisory jurisdiction. That is, for example, a judicial review and appellate jurisdiction in criminal matters from the subordinate courts. So it also has a revisional jurisdiction that is intended for correction of errors of the trial court, which are appealable in law. Thank you.
Thank you, Osodo, for that attempt. That was a very nice one. That was a nice one. Yes, anyone else? Maybe in 1 minute or less. Yes, Melody, your hand is up.
Oh, I'm sorry, that was by mistake, but I can add on. It has, I think he has talked of it. It has original jurisdiction in criminal and civil matters, appellate jurisdiction in civil and criminal matters as well as supervisory jurisdiction. What he might have left out is it has jurisdiction to determine whether a right or maybe a fundamental freedom in the Bill of Rights has been denied or threatened or has been infringed.
Thank you for that contribution, Melody. We have another one. Yes, someone called me Lau Benson. Proceed, Your Honor.
Thank you, sir. I think the speakers who've gone before me have already spoken, but I think it is grounded on Article 165.3 of the Constitution, which confers the constitutional jurisdiction. And basically, like they've said, number one, I think, is unlimited original jurisdiction in matters criminal and civil. In all matters criminal and civil, it has the unlimited original jurisdiction, and the other one, jurisdiction on determination of whether fundamental rights in the Bill of Rights have been denied or violated. And then, of course, jurisdiction to hear an appeal from a decision of a tribunal appointed under the Constitution. Yeah, basically, I think that is it. Thank you.
Yeah, that is very good, and so on and so on. You will also hear the same when you will be reach that topic in your civil litigation. At the same time, you realize they have jurisdiction or hearing election petition that I believe for governors. Yeah. Nevertheless, you realize that under Article 165.3 of the Constitution of Kenya, vests the High Court with unlimited original jurisdiction in criminal matters. Such that now when we go to something called venue of sitting, then for that exercise of original criminal jurisdiction, the High Court is required to hold its sitting at such places on such days as the Chief Justice may direct, subject to the High Court Registrar ordinarily giving prior notice of all sittings, that is CPC, that is Section 70. Then the High Court is also empowered to inquire into and try any offense subject to its jurisdiction at any place where it has powers to hold such sittings. Having said that, you need to now go to your criminal procedure. That is, I don't know if it is section, that is start from 56 or 356, or is it 357 to 360, the aspect of review. That is a special jurisdiction that is given to the High Court, because someone is going to ask you to differentiate between a review and revision. Those are not the same thing. Okay, such that now review, that is in civil matters, section 80, as read together with order 45 of the civil procedure rules, then you will see what is review about. Someone is going to ask you to differentiate between a review and judicial review. So what is this power of the High Court called? Revision, that is anchored in the civil procedure, in criminal procedure code in the CPC. Okay, so if you have that judiciary, is it called judiciary bench book? Can someone correct me? Is it? I know it is called bench book. How is it called? Anyone? Like that I can say it right next time. I used to have mine, but I donated it as a Christian. Anyone who knows that thing, that book? Yes. Lisa, how do you call it?
Are you referring to the Judiciary Criminal Procedure Bench Book?
Yes, Judiciary Criminal Procedure Bench Book. Very, very important. It will make your life easier. So guys, now you will proceed to look at the jurisdiction of the Court of Appeal. Very easy. They look, that is appeal from the High Court and other superior courts, that is the ELC, ELRC. They also have original jurisdiction on the aspect of contempt of court. Okay, I know contempt of court was declared unconstitutional, but they have that powers that they can punish on the aspect of contempt of court. Okay, the Supreme Court, you look at it in the Constitution. I can see International Criminal Court is there. You look at how the role that it plays. Look at Article 17. Look at Article 19 of the International Criminal Code. How do you call it? The convention, ICC convention. It is called the Rome Statute, right?
Yes.
Yes, the Rome Statute, complementarity, those particular principles around it. How does it play the municipal law? At what time, at what point do the ICC come in now? We refer maybe to the, how do you call that prosecutor? The former prosecutor, not Kapenguria 6, but how do you call it? Okay, that person. All right, such that now we move to arrest, guys. We move to arrest. Remember, oral examination will come anywhere. Okay, such that now we move to arrest. Arrest without warrant, arrest with warrant. Very, very examinable. Maybe someone can tell me what is an arrest? Or when does arrest occur? When I'm a CLE, hadi next year? Okay, maybe hakuna mwenye atainua mkono, but it is time to shine. Yes, Milao Benson.
Yeah, in my own words, I think an arrest is the lawful curtailment.
Lawful? Come up again.
But I think I had a network issue. Can you hear me?
Yes, I can hear you now.
Oh, sorry, I dropped off for a moment. I'm sorry. So it is an arrest is the curtailment of somebody's rights by putting him or her under lawful custody.
Thank you. Thank you. The person who had raised their hand, someone called Wekesa.
Yes, an arrest is the deprivation of liberty through elements such as probable cause by the police, citizen, or by a magistrate. Thank you.
Thank you very much. Thank you, Wekesa, for that contribution. Sharon?
Hi.
Yes, hello.
Arrest is the legal confinement of a person by a judicial authority. Let's say a police officer has authority to arrest you. So is the legal confinement by touching or confining someone's body from doing their freedom, from restricting their freedom.
Thank you. That is a very nice definition. I cannot see your hand. Who is this? Someone called Brenda. Brenda, my lady. You can unmute.
Okay. Arrest is the act of apprehending a person for a suspected commission of offense. Yeah.
Okay, so you can arrest someone even before they commit any offense. That is your argument, right?
Right, with reasonable
suspicion. Thank you. Yes, I'm not going to add anything on that definition because if I do, I may spoil it because that is how it is defined. Anyone who is in the class of Mr. Simiyu, listen to him very well on how he how he defined this thing. Someone has turned on his camera. I don't know his name. Okay, maybe you wanted to score some points, but it is in order. Honor, tall, dark, handsome, has beards. Wenye beards, wanajichua. But anyway, clap for him nonetheless. Okay, guys. So now, having said that and having defined arrest that good, maybe let's go with something called arrest with warrants. When can someone arrest someone with warrant? Someone, please. This is where you come in, guys. Very, very examinable. When do you arrest someone with warrant? Anyone, guys? You have been doing really, really well. Tusinyamaze sai. Yes, you will note that criminal proceedings are first commenced by a police officer or a public prosecutor by laying a charge in court, or let's say a private complaint. So I know we will discuss about charges later on. Okay. Yeah, it is number 6, complaint and charge. So there's something that is called a charge. Yes, Wekesa.
If I can take a wild guess, I think you can be arrested with a warrant when you have committed a cognizable offense.
Cognizable offense. You know, that is an oral examination question. What is a cognizable offense? Maybe you can proceed. What is that?
Okay, cognizable offense is an offense that is of serious of which is serious in nature, and mostly it can be a capital. But I stand guided on that.
Yes, you need to revisit your notes. Yes, Mora. That was actually one of my questions when I was doing my oral exams. Yes, Onderi, Mora, you have something for us?
Thank you, Mwalimu. Yeah, in addition to what he has just said, a cognizable offense, it's an offense that does not require a warrant of arrest, and this is an arrest in relation to a felony, and a felony is an offense that is declared to be by law, and yeah, it's punishable by more than 3 years. Yeah, that's all I have to say.
Thank you. Brenda, you can proceed.
Okay, I wanted to say cognizable offenses are those that one is arrested without a warrant and not with a warrant, as he had said.
Is that the position? Yes, I think you will need to work out cognizable, non-cognizable offense. What are those offenses? Because most likely someone will want you to differentiate between the two. Okay, so a court may issue a warrant for the person against whom the charge is preferred. And similarly, a warrant of arrest will be issued by the court for witnesses who have been bonded but failed to turn up to give evidence, and for accused persons who have jumped bail or have absconded bail. That is why you see sometimes if someone has failed to come to court, then arrest warrant is normally issued. It can also be issued to some witnesses. Okay, so the form and content, or maybe the duration of a warrant, you will look at section 102 of the PC or CPC, which requests that a warrant of arrest must be in writing, signed by a judge or a magistrate issuing it, and bear the seal of the court. Okay, section 102 of the CPC. Then who are warrant directed to? For example, when the warrant is signed, whom is it directed to? Maybe anyone can help me with that.
Is it addressed to the arresting officer?
Yes. It is addressed to the arresting officer, or let's say a police. Is it Benson? No, it doesn't. It is not addressed to one person. If you have put your hand up, please maintain your hand. Yes, Benson. It is your time to shine.
Yeah, I wanted to shine with what the previous speaker has said. But what I know is that also the OCS of the local police station is also, I think, has also a role to play. So it must be addressed to him as well.
Yes. Thank you very much. There's nothing that will be digging there. So it is true, section 104 of this criminal procedure, a warrant of arrest may be directed to a police officer or police officers in the area in which the court has jurisdiction, or generally police officers in the area. Okay? So if this is the case, maybe the police officer is protected by, if let's say in cases like this, the police officer is protected by judicial immunity. Okay. Another person, we have section 105 of the CPC, a magistrate is empowered to hold a subordinate, or let's say a subordinate court of first class may direct a warrant to a landholder a farmer, a manager of land, okay? You know, let's say if you are an owner of a facility, such that you can effect that particular arrest. But remember, members of the public can also arrest. I remember there was a time that Matiang'i was maybe disobeying court orders, and some people were saying, you know what, we need to be arrested by the members of the public. Okay. So having said that, there is nothing much there except something called now arrest without a warrant. That is where there is usually a lot of issues, because most of the time we will be directed to maybe look at our criminal procedure, for example, maybe section 29, okay, section 32, section 33, section 36, okay. The definition is in section 21 of arrest, okay. So you will be required to look at those sections, for example, on the aspect of arrest. So also arrest without a warrant. I would not want to go there. Arrest by private person is in section 34 of the CPC. So maybe we can go to the identification parade. We are skimming through. I can see people are disappearing, people are going. Identification parade, identification parade. Who is going to help us with that? Very, very examinable, easy marks, 10 marks or 7. Yes, weka mkono juu. ID parade. Yes, Kevin. What is identification parade?
Identification parade is an exercise that is usually undertaken in order for a complainant or a victim to identify the propagator of the particular crime.
Okay. Thank you for that. Sharon, then Wekesa will come.
Identification parade is the process whereby a witness tries to identify the perpetrator of the offense from, let's say, a group of members that are listed in the P156 form, and it's supervised by the IO and the corporal. I think it's a corporal or what? Yes.
Wekesa?
Yes, an identification parade is an investigative tool used by the police to identify a suspect who has been placed among several other people of the same class, same height, similarities of the same kind. Thank you.
Thank you. I believe on the aspect of definition, we are good. Because when a question will come on the identification parade, it is good to maybe illustrate or define what identification parades are, such that now when someone is going to tell you to conduct the identification parade or to give the identification parade, then you will be able to advise them appropriately. And I'm going to tell you shortly how those questions normally come. Mora?
Okay, I was just seeking a clarification because there's a speaker who has said that an identification parade is done by the IO. I wanted to confirm whether it's done by the IO because I think I saw something like it's not done by the investigation officer, the one who is in charge of that.
Yes, thank you for that. Yeah, it is not done by the IO. I believe the person that does it is someone that is above the rank of an inspector or something like that. Ama namna gani? Let me hear what you have to say. The conduct of the ID parades, how are they conducted? So on that end, it is like the procedure. What is this procedure of conducting an ID parade? What is normally done? Anyone? Anyone? Yes, Mora.
Okay, I'll just try. So when the suspect is supposed to be lined up with at least 8 people, then
where do you find it first? Under the National Police Service standing orders?
Yeah, it's in the standing orders.
Number?
Okay, I'm not sure of the number.
Okay, proceed.
Okay, so the suspect is lined up with at least 8 people. Then the witness will be required to identify the suspect from the lined up people. The people in the identification parade should have similar characteristics. This is with regard to the height, how they look, if perhaps the suspect has an injury, maybe they can wear Marvins if the injury is in the head, so that the witness does not identify him, and it's not peculiar, it's not easily visible for the witness to distinguish the suspect from the other people. Then in the event where the witness requires the suspect to speak, all the other people in the parade will also speak, so that it will not be discriminatory to the suspect. And after the identification parade of one witness, then the suspect can request to change a position in the where they are standing, that is. And afterwards, after the conducting of the ID parade, the suspect can sign the form, is required to sign the form. Yeah, that's all I can state about the conduct of an ID parade. Thank you.
Thank you for that. Anyone else? You see, you guys have studied. You are already in third term. That is very good. And anyone else? Maybe something that she has forgotten? Because sometimes you will be required to list them. At least 8, at least 10. What is the authority? I have not heard anyone talk about any case. Or someone is going to ask you, so and so, can you please tell me what was the position in the case of Republic versus Mwango, or something like that? Mora? Yes, you can.
Okay, actually, in relation to the case you've mentioned, can you hear me?
Yes, I can hear you.
Okay, in relation to the case that you've just mentioned, R versus Mwango, the court stated that the value of identification as evidence will depreciate in a case where it is done unfairly and contrary to the police standing orders. And also, an ID parade, it should also be noted that an ID parade is conducted for a suspect that the witness does not know. And in the event where the witness knows the suspect, the ID parade will not be necessary, since it will beat the essence of the ID parade, since it will just beat the essence of the ID parade. And this was stated in the case of Stanley Koech and 2 others, where the first PW1 was the appellant's stepmother, while PW2 was their father, and the police conducted an ID parade. In this case, the parade was held to be valueless because the witnesses knew the accused person. So in short, for an ID parade, the suspect should not know the witness, and the event where they know each other, it will beat the essence of the ID parade. Thank you.
All right. Thank you very much for that. So now you will understand that, for example, in the case of ID parades, if you have an authority, well and good. But when you go to that exams, or maybe maybe in oral exams, you just cram at least 8 or at least 4, and you will be good to go. You will be good to go because this is really, really examinable. Okay? So go to the National Police. I know it was amended. Go to the National Police standing orders and see they have been listed there. Okay? The accused or the suspect person will always be informed of the reasons for the parade and that he may have a solicitor or friend present when the parade takes place. Number one. Okay, that particular person, that accused person, must be informed of the reasons of the parade. And if he so desire, can have a friend or his advocate present. Okay. Number two, the police officer in charge of the case, although he be present, will not conduct the parade. That was the point that one of you raised before. Very, very important. If you cannot remember them, grab them anyway. The issue of understanding, you will come and find out here in practice. But weka kila kitu kwa kichwa, ndio upite hiyo mtihani mara moja na uende nyumbani. Kitu kama uelewi, cram. Usiambiwe otherwise. But if you can understand, please understand. It will make your work easier. Number three, the witness or witnesses will not see the accused before the parade. Okay? Number four, the accused or suspected person will be placed among at least 8 persons as far as possible of similar age, height, general appearance, and class of life as himself. Should the accused or suspected person be suffering from disfigurement, steps should be taken to ensure that it is not especially apparent. Someone talked about that. Very, very important. Okay, the accused person will be allowed to take any position to choose and will be allowed to change his position after each identifying witness has left, if so desire. Okay, care will be exercised that witnesses do not communicate with each other. Every unauthorized person must be excluded. So now it is upon you to go there and look at those as provided because they are not complicated. Get yourself 3 authorities and cram at least 8 or 10, you will be good because they are several, almost 16 or thereabout. Okay? So that is all I can say there on the ID parades because we are skimming through. I'm not teaching the whole course like in one night. Okay? Can I go to number 5, guys? Time is not on our side. I know we can finish maybe in the next few minutes or so. I can see several persons have already left, but that is fine. The number is good. Any question, guys, on the ID parades? Okay, silence means no question. So colleagues, on the aspect of preparation of files for trial, this is usually my best topic. And the reason it is my best topic is because I used not to understand the aspect of preparation of file. But you realize someone is going to come to you, PC Kanyungi comes to you, he's having a trouble on how to conduct the investigations. He now need your help. Crime rate at Kariobangi has been really, really up. So he wants you to assist in the investigations and how he can arrange his files properly. So now, as a newly admitted advocate, please advise PC, can you? Because no one is going to tell you to highlight or to enumerate the contents of a police file or the prosecution's file, the advocate's file. So maybe this one is usually straightforward, but the question will not be like straightforward. So can someone tell me what are the contents of the police file, sub-file, this, sub-file, this, what is contained in this particular sub-file? Yes, anyone? Anyone? Contents of a police or prosecution file? Kimbia haraka haraka. Yes, Wainaina Caroline, please proceed. Then
Hello, I know that
Anyango June will come.
I know that subfile A is the initial report, which covers the initial reporting of the case, and subfile B has the occurrence book, and subfile C, I believe, also has the evidence, covers what is the exhibit. Sorry, I think that's what I know so far. That's what I can easily.
Thank you, thank you. June, then Sharon will follow. Then Mora will come last. You want to add something?
So, police.
We cannot hear you,
Police
June.
file has some files A to J.
Mm-hmm.
I believe she has mentioned A, which consists of the initial report, and file B, which usually has photographic evidence. Subfile C usually. Can you hear me now?
Yes, we can hear you. Please proceed.
Subfile C usually contains expert reports, such as the morgue. Okay. And then we have subfile D, which consists of witness statements. Subfile E, which consists of statements of the accused person. We also have F, which is the investigation diary of the investigating officer, which he notes down the chain of custody if there was certain things that he obtained and traces them to the end of the investigation. We have subfile G, which is the charge sheet or information. Subfile H, which consists of exhibits, previous records of the accused, and lists of witnesses. We have subfile I, which is the covering report. This is usually basically the summary of the case. So he highlights everything from when he received the reports to how he conducted the investigations, everybody and everything that he went through is contained in I. And then J will be the correspondence. These are usually the communications that he has with the office of the DPP. Yes.
Mm-hmm. Thank you very much. So Mora, and then maybe you can proceed and tell us something about the contents of the advocate's file.
Okay, thank you. The contents of the advocate's file, this include the instruction note. This is what the clients tell you to represent them and what you are required to do. So this tells the client's intentions. It also contains the client attendance form. This indicates the name of the client, the date of the attendance. This is used in the billing of the client because I believe advocates bill according to the time they use in in a case. So this will help them do that. The court attendance form, the court attendance form contains the name of the advocates in court, the judicial officer, the reason for attendance of court, and the next court date. It can also contain a copy of the charge sheet. This is obtained from the prosecution upon request. It can also contain the bail or bond documents in the event where your client is granted the same. Yeah, it can also contain a list of the defense witnesses and their witness statements. Yeah, that's all I think the advocates that I can think of at the moment.
All right. Thank you very much. Is that Sharon? Yes, Sharon. Yes, Sharon, your hand was up.
Yes, I wanted to ask if the advocate's file should have the list of authorities or the written notes where should which as the opinion that was given to the accused.
Not necessarily, but if it is there, it doesn't harm the case in any way whatsoever. So yes, it is not mandatory, but it can be there as well. Okay. So I think, yeah, I think you guys, this aspect, you have understood it better than I was when I was still at the Kenya School of Law. But you tend to forget, so you need to see what song you will sing. Most of the time, it is the first one, the contents of the police/prosecution file. It is very, very examinable. Okay, both even in your oral exams and as well as this bar examinations. Advocate's file, somehow not that much. The court file, not that much, but you need to look at it, because unless now when you become a judicial officer. Yes, Onderi Mora, your hand is up.
Okay, I had a question in relation to the prosecution file. I'm seeking clarity whether the initial report is the same as the custody record.
Initial report, custody record. I can confirm that, because I have always known it as an initial report. So maybe you can, I can confirm that first before I give you what I think. Is that okay, Mora?
Okay.
Yeah, remember, I'm someone who practices civil litigation. I don't do criminal law. Nonetheless, I will be able to get back to you on that. Cindy.
Okay, thank you.
Yes, or those who will want to go to court, maybe the contents of the court file, I don't know, because it is like in 4 parts. There is the top cover of the file, coat of arm, court's name and place, type of case, case number, stroke year, name of the case, that is Republic versus Konambaya or something like that. Then you go to the first page, whereby you'll have the date, then the name and rank of the judicial officer presiding over trial, name, rank, and designation of the prosecutor, name of accused person or accused counsel, even where an accused is present or is represented by counsel. Okay, and the fact that the accused is present should be recorded, name of a clerk, name of an interpreter. If you are going to do your pupillage in judiciary, you will be really conversed with this. Then there is plea taking proceedings. Okay, then the documents in the court file, such as the charge sheet, bail and bond documents, particulars of surety document, release or custody order of the accused, court exhibit list, and court list of witnesses. So for those who will go to court, then you will be able to maybe know it better than the rest of us who are not judicial officers. Okay, nevertheless, try as much as possible to see what you will do about the contents of the police/prosecution file. The advocate's file are really, really straightforward. If you have those notes, you will be able to comprehend them. They are not as complex as those ones in the prosecution or the police file. So you will realize when we will start our revision, how these questions will be asked, they will not be straightforward. Okay? Someone is going to tell you to go and assist a police officer with the investigations. So when you say the police should first do this, the police should first do this, actually that they're asking you about the prosecution stroke police file. Okay? I was constrained. I didn't want to go to complain and charge because it is something that is complex. It may even need a day of its own. What was your name? Our assistant, the one that is sharing the course outline? Yes. So complain and charge, maybe someone else is going to come maybe before we start our revisions, because I know you guys are going to enjoy when we will start our revisions for orals, because it is a normal question, answer. Last year, we had people over 300 attending our sessions and things like that. Okay, then plea and plea bargain. Okay, plea taking, plea agreements, and stuff like that. Okay. So I wanted to stop there for now, because I cannot teach the whole course like in one sitting. I know you guys are tired and we started early. Okay. So maybe someone who is really in criminal law, I can ask him or her to start with charges, and then maybe we'll need another session so that we can tackle the major ones like plea taking, like charges. Go down. Enda chini kidogo. Bail and bond, very, very important. Another one. Pre-trial conference, that is like a 1 minute or 30-minute thinking. Then the trial process, very, very important. Yeah, so I will ask maybe the next person that will come to do this to start with the charges. So unless if someone have a question, maybe you can ask before we close off. Anyone? Kama kuna mwenye ako na swali, be it maybe on maybe project work, or maybe I'm not saying I'm going to go deep in it, or maybe how things are right now. I don't know if your term one is already done, or you are still in term one. The school is closed. When is term two? Anyone? Yes, Sharon.
Thank you. I wanted to ask about the P156 forms. In circumstances where we have like 3 people who have been arrested during, let's say someone has went to the police to state a complaint, and at the same time they arrested like 3 people who couldn't like account for what they're doing that time. So at P156, do we like prepare for each accused person when doing the ID parades, like, or we enjoin them when we are stating the name of the accused?
Yeah, you see that is a very good question. Normally you can maybe use one person, but the key word there, if you look at it, is state at least 8 persons. So even if you have 3 people and you put like 17 people among the middies, then it is it. But if you want it to be done properly in a way that it cannot be challenged, then maybe you can use one person, then the next, because you see their physical complexity will not be the same. Okay, maybe one person, because you cannot tell me the three offenders, all of them, they look alike, they are of the same height, they are of the same body build. So it would be fairer or nice if you can maybe use one in one in one ID parade. And remember, everyone is charged differently. Even where they are charged together, everyone is facing their own counts. So even if they are both charged jointly, remember each person, even when sentencing will come, you individually, you will receive your own sentence. So if you want your ID parade not to be challenged, then it is safe if you can use one person per parade, but not putting three of them, because if the body build is not the same, the skin complexion is not the same, then your parade will be subject to challenge. Thank you for that question, Sharon. Anyone? Okay. I believe that is it then. I'm not seeing any hand. The recordings will be sent to the group. What I want to say is, guys, this thing is not rocket science. It is something that has been done, and it is usually easy if you do it on your first attempt. So just for these 9 months, keep your head down, do whatever you can do. Attend all classes, even if you don't read, I can advocate for that. Anytime, any day, please attend all your classes, attend your meetings. This is a 3 exams process whereby you must do project work, you must do oral exam, then now finally your bar exams. If you are pass these 2 examinations, at least get a 30 out of 40, that is orals and project work combined, you will have easy tasks ahead of you during bar exam. Personally, I was lucky. My minimum was 30 out of 40. So basically, when I was now going to do my bar exams, I was just looking for 20 marks. So it didn't matter what type of exam they said, they turn it upside and down. I will look on how I will get those 20 marks. Calculator become very important in that term. So give your project work your all. Oral exams, we will help each other. You will see the questions that will pose to you. Most of the questions will come. Although it will not be asked to you individually, most of the questions will come. So I encourage you guys to keep studying. Don't stress yourself. Enjoy yourself reasonably. Okay? Kama ni sherehe, you can try kidogo, then you go to class on Monday, you pangai your time well. So that is all I can say, guys, for today. We will meet when we will have our civil litigation. I believe there are issues that we have not completed there. And then we will have our weekly discussions when in term 2, when we'll be training you on oral exams. So that is all I can say, ladies and gentlemen. Thank you all for joining. We can maybe pray. Dear Heavenly Father, thank you for what we have learned, what we have understood. Guide us over the weekend. Give us energy to start the week. In Jesus' name we pray and believe. Amen. Thank you, guys.
Amen.
Members can leave at their own pleasure.
Thank you so much. Have a good one.
All right, you're welcome.
Thank you.
Welcome.
Thank